Just to be clear, none of the situations that Justice Alito is pointing to are the facts of this case, correct? Or the facts of this statute?
That's right. So
and the constitutionality of this statute is what's at issue.
Yes, and the Fifth Circuit invalidated the statute on its face. I do want to suggest that to the extent the court has been left with the impression in some of these amicus briefs that the protective orders are routinely entered without a basis to conclude that someone actually presents the individualized finding of danger, I do not think there is any record or evidence to support that conclusion here. And I would say again, this runs counter to the presumption of regularity that the court ordinarily affords in this context. But I think it also runs counter to Congress's recognition and circumscribing of Section 922G8 to ensure that it's covering those who had notice and an opportunity for a hearing. And
Counsel, in the end, if there are due process failures in any system, that'll be subject to a separate challenge, correct?
That's correct. And Mr. Rahimi hasn't made a due process claim here. He's not challenging Section 922G8 on that independent
I'd like
ground.
to go back to your law-abiding or responsible citizen category. I now understand why you think it's appropriate. You think dangerous is too limited because we have restrictions on the age of people possessing firearms and on the mentally ill. And they're not, why do you, and I understand they're not necessarily dangerous, but I guess their lack of responsibility or judgment could be questioned, correct?
What I would say is we think that they are inherently dangerous, even though they might not be culpable or intending to create that kind of danger with firearms, that there's an inherent risk based on their qualities or characteristics that demonstrates that as compared to the ordinary citizen, allowing them access to firearms is going to present that risk of danger to self or others.
So if we use danger in the way you're defining it, as broadly as you're defining it, you don't need responsible citizen category.
Yes, I think these are essentially getting at the same concept. I guess what I would say, Justice Sotomayor, is that we have tracked the court's own language here, and I think it would be important if the court wants to refer to concepts of dangerousness to make clear that it's not backtracking from what it said in Heller and in McDonald and in Bruin that you can disarm those who are not law-abiding responsible citizens, with the mentally ill as one of the exemplar categories the court held up to illustrate that proposition. And I think that the term responsible gets at the broader group of people who can be disarmed even though they might not be culpable precisely because of this risk of danger. But
Thank
if the
you,
court,
Counselor.
Can you finish that answer?
I was going to say, but if the court were to refer to these concepts of dangerousness, I just think it would be important to make clear that it's not backtracking from what it has said in prior cases. And it's not just that the court has referred to this concept in the abstract, it's actually embedded it in various aspects of how Second Amendment analysis operates. So, for example, the court has said background checks are okay because they're intended to decide whether you're the kind of ordinary law-abiding responsible citizen in the first place, or that when you're looking at whether a weapon is dangerous and unusual, you should ask, is this the kind of weapon that a law-abiding responsible citizen would need for self-defense? And so I just think there's a risk of creating confusion about that.
Thank you, counsel.